Any mention?
May I please, Your Worship?
Yes.
My lord, I have mentioned for unlisted motion upon criminal petition. But in a session travel case, my lord, for non-appearance of accused, my lord, the learned session judge has issued non-bailable warrant of arrest against the bailor, my lord. Now the bailor is before Your Lordship, seeking quashing of
It
the.
must be continuous default then. It is not that in because of the single non-appearance, this order has been passed.
No, my,
It must be that the accused has defaulted in appearance repeatedly.
I'm not the accused, my lord. I'm the bailor, my lord.
Okay. But the thing is that if you're a bailer, then you take the responsibility. It is your responsibility,
But there's
isn't it? So it must be that the accused has not appeared before the trial court
Yes, my lord. That,
on more than one occasion.
yes, my lord.
And thereafter, bailer was given notice.
Notice was issued, but
Yes.
my lord, what happened, my lord? Initially, my lord, one bailable warrant of arrest was issued. That was not executed by the authorities, my lord. Now, subsequently, my lord,
It's a bail matter.
it is a
It's a bail matter.
Yes, my lord, this is a criminal petition, my lord. I'm with the criminal petition, my lord. Before.
Anyway, it's tomorrow.
My lord, tomorrow is Saturday, my lord. Only the urgency is that, my lord, non-bailable warrant of arrest has been issued against the bailor for non-appearance of the accused, my lord. Now, there is a provision in the CRPC, now the BNSS, that the court can realize that surety amount as fine, my lord. That provision is there.
Yes, okay, that is in case of default. But then your primary duty is to make the accused appear before the court.
Correct.
Anyway, we'll take up. Just
Lordship, always.
Yeah, please, Lordship. I beg to mention item number 9 and 10, Lordship.
yes.
Yes, I prefer the matter may come up after 2 weeks, Lordship.
No objection, Lordship.
9 and 10. Prayer made on behalf of the petitioner. Yes, after 2 weeks. Yes.
Excuse me. May it please your Lordship, I beg to mention item number 8.
Yes.
Lordship, I pray for 1 week time, your Lordship.
What is this matter about, madam?
Challenge against court-martial proceedings, your Lordship.
Yes.
No objection, Lordship.
This is also the request of petitioner. List after?
Yes, your Lordship. After 1 week, your Lordship.
After 1 week will possible. After 2 weeks, it will go after 2 weeks. It will after 2 weeks. Yes.
Deeply obliged, your Lordship.
Your Lordship, I beg to mention item number 11. The
Yes.
conducting counsel having some personal difficulties, Your Lordship. Let it come after 2 weeks.
No objection.
11th. The request made on the petition. List after 2 weeks. Yes.
Oblige, Your Lordship.
With reason.
Yes.
Lordship, the joint mention prayer for item number 12.
12.
Will this matter come up after a week? Next week?
There will be next week will be difficult, Mr. Gautam. Next week, I think.
2 weeks.
Then after 2 weeks in that case.
2 weeks. 2 weeks. Yes, Lord.
2 weeks. 2 weeks. The request of the petitioner. Yes.
Oblige.
May it please, Your Lordship. Your Lordship, I beg to make a mention of item number 6, Your Lordship.
I'm appearing for respondent 1
Your
2.
Lordship, kindly this matter may be listed after 2 weeks, Your Lordship.
Item 6.
Yes, Your Lordship.
And for the private respondents,
I'm for respondent 1 to 3, your Lordship.
This is a Nakma matter.
Your Lordship, in Okma matter, Your Lordship.
No objection, Lordship.
One request made under the petitioner. Not objected to the learned counsel appearing to the respondents. List after 2 weeks.
Oblige, your Lordship.
I'd like to mention item 4, my lord, of the hearing list. Let it come up, my lord. I'm praying if this matter could come up next week, my lord, subject to your lordship convenience.
Next week, things may be a bit difficult because already I think it's overboard, rather you can say, like, so listing it 2 weeks later.
I can have it after 2 weeks, my lord, subject to your lordship's convenience.
No, Lordship will correct. For more than 6 months, they are supposed to produce the earlier round of records. And in the middle of a hearing, the only very limited issue was kindly produce the writ petition so that court wanted to see the prayer part. So I don't know whether they have produced that at least.
Is it not a
my
case
lord,
about the allotment of?
Lordship is
Right,
correct.
right,
And enforceable right, Your Lordship. For last 50 years, the allotment was not completed, and
The case which was projected by the private respondent in that, though the allotment was made, then they have never taken over the project.
absolutely.
That is
And since 1950,
no,
Your Lordship.
no right.
And our Lordship, the state's contention was that no subsisting right, Your Lordship. The question of enforceable right does not arise. So, Lordship, in the middle of hearing, Lordship wanted to see in the earlier round of litigation what was the prayer. So, that's how last 3 months back, Lordship, we got stuck up in that point.
Anyway, we'll see it then on the next.
Yeah, Lordship.
If you are not objecting to the prayer of
No, Lordship, we are not objecting. The only thing is if they can produce that so that it will be easy.
on request made on the petitioner, not objected to by the counsel of the respondents. Distributed 2 weeks. Yes.
Similar pref item 5 as well.
Why? These are all. See, all these old matters. You see, you are these old matters. You are repeatedly asking for time. 2015 matters, 2016 matters. We do not know what is the purpose. You see, what is the difficulty and how you have a. Seems like your difficulty is persistent. It's there. It never
But
goes.
here, my lord, some of the petitioners has expired. So, my lord,
Accordingly, 2006, the previous one was 2015 case, this is 2016 case.
And they
you
have to be, my lord,
You have developed the habit of mentioning all those old cases.
and,
See, just it is you make the court harsh. That is a problem.
my lord, let it come, my lord, if that be the case.
Yes.
No,
Same order like before, 2 weeks. Item 5 and
4 and 5, my lord. 4 is already mentioned, my lord. 5.
yes.
All right.
Obliged.
Lordship, 7, I was looking for my learned colleague, Shimrasho. Lordship will recollect, matter was heard, and Lordship wanted few bullet points note.
Yes.
So we have already given to the court.
The other side is also ready. Is ready with the thing. So we'll see it. Wait, let the matter come.
Let them know. Number 7, Lordship. Okay.
Yes.
Supplementary causes, item number 1.
Yes.
Please, Your Lordship. Should this matter may kindly be taken up next week? Conducting counsel Mr. Hassan has some personal difficulty.
On request made on behalf of the petitioner, list after a week.
Much obliged.
Daily cause list, item number 1.
In this matter, the private respondents had sought time to file their reply.
May I please, Your
Yes.
Lordship? During the course of the day, I will be filing my
So when shall we have it?
Respondent number 5 in
When shall we have this matter?
After 2 weeks, ma'am.
after 2 weeks.
Yes, Ms. Eddie Sharma,
Edition.
London Council appearing for the respondent number 5 and 6.
5 and 6.
5
4
and
is
6.
unrepresented.
Submits that the objection on behalf of the said respondents will be filed during the course of the day. Give paragraph. Spread for by the parties. This is matter after 2 weeks.
2 weeks.
Yes.
Item number
Much
2.
obliged. My lord, in item number 2, I am imitating attendance on behalf of the respondent number 2.
Yes.
Well, there's also a possibility of settlement. We have reached
Yes,
out to
that is what the submission
Yes,
which was made.
We have already started the process. We have already got in touch with the private
It's
respondent.
better you do it.
Yes, well, let's give 2 weeks time. We'll try and close this.
Okay. We'll just record his appearance today and let him take instruction.
Lordship,
We will have to file a reply as well, ma'am.
It's okay. That you can do it. You can do it. You can do it. Okay.
Lordship, only small submission on the last location. Lordship will recollect that page 29 was not legible. 29, that FIR. So kindly if they can supply.
Just communicate.
I thought they had.
I'll
Do not tell the
provide a
court
copy
to
to my
pass
senior.
any.
I'll provide a copy to my
Please,
senior.
please take care.
I'll
They were banned.
I'll provide a
You
copy.
see, this matter, so far as this court, remember, the interim order was passed on the consideration of the fact that submission was made by Mr. Paul.
Yes.
That
Yes. We are just seeking
you
2 weeks
settle
time
that.
to.
You do it. Okay, Mr. M.U. Ahmed, Landed Council has entered affairs on respondent number 2 and prayed for grant of some time. Okay, we'll say that for filing an objection in the matter. Stop. Prayer allowed. List after 3 weeks.
No, the interim may continue.
The interim order passed earlier shall continue till the returnable date.
I'm
Settle
grateful.
it, settle
Yes,
it.
yes, yes. I'm grateful.
Item number 3.
May I please,
Yes.
Lordship? We require some more time, Your Lordship, to file the affidavit. So kindly grant us 2 weeks time, Your Lordship, to file the affidavit.
Let's pray for why. You are appearing for?
Appearing for the respondent, all the respondent, GHDC.
JGDC, there is no private respondent. Okay, as prayed for Esdar.
Yes, Your Lordship.
Esdar, Landed Council appearing for the respondent. How much time you need?
2 weeks time, Your Lordship.
Further 2 weeks time is granted for filing counter
Hello,
affidavit in the matter.
Hearing, item number 7.
Yes. Yes, Mr. Khan, what was the matter about? The argument is, oral argument is concluded.
So Lordship, matter was
Promotion.
Lordship, promotion. So
Yes.
I have made a brief note also. Lordship will see kindly my written argument.
Okay, you filed your written
we-
argument.
we
You make
filed.
a very long argument.
No, Lordship, you just try to bring the facts. Because there were some facts I thought Lordship
See,
was
what,
difficult.
what this court needed is that clarification on 2 issues. One is that before the expiry of the time stipulated in the notice, you have considered the promotion.
Correct.
Second is that non-completion of the period of the
15
service, the qualifying period of service.
Qualifying period, Lordship, we are answered by Rule 67. There was a rule that says he had complied because the period of 15 years will be from the date of, the rule says from the date of first day of the year. Lordship, I had read out.
That is one the confusing part. Anyway, we'll just see.
I had given.
You have given me like a Any decision with regard to
Lordship.
that? No, interpretation, manner in which that rule has to be interpreted.
Lordship, that was not required because the rule clearly covers.
Okay.
But Lordship, we have relied on one decision. Lordship, can you throw it? Lordship, their admitted plea was that the rules 2017 was prospectively applicable. And they have relied on one Supreme Court judgment that says, like, past service will not be considered if one is own.
If there is a transfer part.
Yes.
If there is no choice posting
Yes.
sought for.
Yes.
Moment you do it, then your seniority.
Will be. So they have relied on a judgment. Your Lordship,
That is a decision.
I have quoted the judgment, saying that judgment is applicable to us. So that was a too important issue.
Okay, we'll just take care of this.
Lordship, please. I have given a bit detailed discussion also, Lordship, because I understand sometimes after 2 weeks things gets.
The parties have submitted their written notes of argument. Then it's the judgment result. Yes. That's
All right,
we'll see. The only thing is that court will have to refresh the mind.
Lordship.
Yes, yes.
13.
The parties have submitted their respective written. Their respective written. Yes, Mr. Yuvan.
My
What
lord,
is this?
so it's a gist of the arguments, my lord. I'm just submitting, and I'll, as I,
Then you
my
will
lord,
orally address.
my lord may refer as I.
Yes, that is better actually.
So there are two appeals, my lord. That is the appeal number 13, item number 13, and item number 14. That is criminal
Criminal
appeal.
appeal number?
59 and 60, my lord. I am submitting the same thing, my lord, because these are two brothers convicted by the common judgment. Allegations are same.
Same paper book.
Yes, the same paper book. Of course, there's different paper book, but it suffice.
Contents are same.
Contents, everything is the same.
No, but then you will be referring from which paper? If the pages do not tell you, then it will be a problem.
My
again.
lord, I will be referring from Comia's paper book then. On the last occasions, I've referred to Lois, my lord. Lois, in fact, I have concluded my submissions, and then whatever points that I have raised, my lord, I have given in my gist. And today comes for the Comia's, my lord.
That is okay, but then what about the reply in that first case? You will be addressing it after he finishes, concludes the second one.
My lord, I think I will require to file my reply.
No, that is all right, but then you have to address the court orally also.
So,
Your oral submission will be needed. You have not addressed the court also. It is not that only the written, you submit your written and
Because I
you have to explain it. You see, court may not, going through court may not understand anything. So, see, Mr. Yuvan he says that he has almost completed that one, the criminal appeal number 59. Now, before he proceeds with criminal appeal 60, do you want to address the court with your argument, or
Connect it, my lord. Let him sum up his.
so you will reply both together?
So, my lord, just to
So right now you want us to take up which matter?
Comia's, my lord, because for Lois 59, my lord, I'll just
So this notes will cover the first one, not the
first
second
one, yes.
not the second one.
The second one also will be there, my lord, all the points, but except for one, my lord. TIP was conducted in respect of the second one.
Has it been clarified here?
Yes, yes, it is clarified there, my lord. So there is only difference, my lord. The first one, no TIP. The second one, there was a TIP. So that is the only point, my lord. I will not go back to the facts of the case, my lord. The facts of the case is that there was an altercation happened because of parking issues in Molanghat parking lot, owing to some parking fees, my lord. And there was a fight, and in the fight, allegedly, one of the disease sustained, and he was brought to the hospital. He died there, and subsequently, my clients got arrested, got convicted under. Initially, it was under Section 302, and then, but then subsequently converted to Section 304, and convicted under Section 304. That is a punishment for murder, not what,
Culpable homicide,
culpable
not amounting to murder.
culpable homicide not amounting to murder. So that's some substance of the case now. Now, my lord, for commerce to dong, my lord, the question here is whether TIP, whether on the basis of the TIP, a conviction can sustain. Because TIP itself is not a substantive piece of evidence. It's done during the investigation for the purpose of corroboration. That's all. Now, the prosecutions have relied very heavily on two prosecution witnesses, prosecution witness number 1 and prosecution witness number 9. So prosecution witness number 9 is the complainant whose brother died in the alleged incident.
Whether the complainant was present at
The allegation was that the complainant was present there, my lord.
place of occurrence.
Place of occurrence, and the PW1 was also present in the place of occurrence as per their statement, my lord. But their statements, number one thing, they are interested witnesses. Why? Because they have been called to the place.
What is the law with regard to interesting witnesses?
My lord, when you have, when we allege that there is a interested witness, then more strict scrutinization has to be done in a trial court, my lord.
But then
It is, we cannot discard just because they are interested. No, I'm not saying that. But then you have to be more strict if the allegation of this thing is there, my lord. And if any independent collaboration is there, then you need to bring on it. Here, my lord, both of them are interested witnesses.
what happens if there is no independent corroboration?
If, my lord,
So
if
whether the statement of the interest witnesses
Yeah.
will have to be rejected.
No, I don't say that. You cannot reject, you cannot brush aside their statement, my lord, if they say that we were present. But the only thing is that it needs to be scrutinized properly to find out the veracity of their statements, how truthful it is. Now, in this case, what happened is, they say that we saw 5-6 boys coming armed with hammers, dagger and rod. And they said, yes, these people were fighting. They were all scattered, helter, everybody was jumping around fighting. And none of these PW1 and PW9 stated that it is me who did the overt act, who assaulted. Now, assaulted with what? Whether it was with hammer, whether it was dagger, whether it was bottle, whether it was a rod, they said, we saw, oh yeah,
Out of 9 witnesses, how many are eyewitnesses?
2.
What are their evidence? Can we go?
Yes, my lord. Now, my lord,
How many
12, in fact,
supplementary this thing are there?
I'm sorry, my lord.
How many supplementary paper book is there?
No, there's only one supplementary paper
Why
book, my
there are
lord.
2 copies of
No, 2
supplementary
copies would be for different case, my lord. 2 supplementary for different.
say-
One is 60 and one is 59.
60. Here both are 60. This is 60, isn't it? Supplementary. So it is, no, this is 60. We are sharing now 60. This is 59. 59 is already there, I think. That's okay. Give me one. Yes.
Now,
Where is
my lord may come to page 57, my lord. Page 57.
Page 57
Yes, my lord. Page 57.
of the main paper book.
Yes, my lord. There's a main paper, page 57.
Now, you have not taken us to the judgment. See, Mr. Yuban.
My lord.
Anyway, before let us first finish the evidence.
Yes, my lord.
Take us to the judgment
Which
and
part of?
especially the finding.
Yes, my lord. So, my lord, let me take this one and give submission and why the judgment is bad in law, erroneous, that we can relate later, my lord.
Okay, as you want. Yes.
My lord, this is a deposition of PW1, page 57, my lord. Page 57, my lord.
Just a minute. Yes.
His name is Silverstar Khongsit, my lord. So I read his judgment on oath. I know about this case. It was Sunday, Holy Festival, in the year 2011. The younger brother of the deceased called up his own brother who was with me at that time. After that, we went to the spot. The incident had already taken place, and 4 or 5 people came to us and started assaulting both the brothers of the deceased, but they did not do anything to me. I can identify only 1 out of the 4 or 5 people who had beaten up the brothers of the deceased on that day, and the accused is present in the court dock today. The witness pointed out at Louis Dotudong.
That is the only thing here.
Yes.
Now, just a second.
Yes.
Just pause for a while. This witness says
Yes.
that he has seen the
Yes.
accused assaulting
Yes.
the brother of the deceased, not the deceased.
Yes, the brother of
Isn't
the
it?
deceased. Exactly.
So
my lord.
he is not an eyewitness to the occurrence.
He is not an eyewitness to the offense, my lord. So,
There is a clear and very cryptic evidence.
my lord, my lord.
And he doesn't say anything that
Yes.
he saw
Yes.
the accused hitting the deceased.
Yes. He never said
And
like
so far as this case is concerned,
that. Yes.
no allegation of assault of the brother of the deceased
Yes.
has been made a part of the charge, isn't it?
No. Yes, my lord.
So there is no question. So whether he has seen it or not, it
Yes.
falls outside
Yes.
outside the trial of this case.
Outside the trial of this case, my lord.
Yes.
So,
Is it that this court is prejudging your submission?
my lord, because my lord, while doing administration of justice, my lord, we'll have to go as per what comes out on the record, my lord. So sometimes, my lord, things which is before us, we cannot close our eyes also. So,
Just a minute. Just a minute. No. See, we have to strictly go by the
evidence, what
whatever
is on record, my lord.
You see,
My lord, now,
just a second. Just a second. Let us note it first.
yes.
So you see, like, basically, we do not know. Like, so far as this witness is concerned, he has nothing to do with the allegations.
With the allegation, has nothing to do, my lord.
Yes.
So, my lord,
Anyone, you want to refer to the cross-examination of this, or?
cross-examination, my lord, once they have not said anything, my lord, it may not be very relevant to go to the cross-examinations. Rather, I would like to go to the second prosecution witness, my lord.
Yes.
The PW2 is a second prosecution witness. Now, my lord, the second prosecution witness is Milton H. Sangma, my lord.
How you said that there are 2 eyewitnesses? He is not eyewitness.
He is not eyewitness, my lord. So, prosecution, because this case can go as bad as it is possible, but however, convicting in this such kind of case, convicting the accused person, my lord, that was bad in law, my lord. This is what I wanted to point out. Because Milton H. Sangma, he is a person who has not witnessed anything, my lord. He says,
Yes.
I joined the police department in the year 1983 as constable, and I got promotion as a head constable in the year 2008. I was on duty at Bara Bazar. I do not recollect the date of the incident, but I remember that I received a phone call from OC KP Singh, who is the OC Cantonment Beat House. On receiving the telephone call from mobile from him, he informed me that there was an incident in the parking lot. There was an accident, note this word, my lord. Accident in the parking lot just nearby Cantonment Beat House. On receiving the telephone call, I immediately proceeded to the parking lot with some of the CRP personnel. On reaching the place of occurrence, I found one person was lying on the ground, and on seeing the person, I immediately called KP Singh, OC of Cantonment Beat House, informing him about the man lying in the parking lot. And the OC of the Cantonment Beat House informed me through telephone that he will send one vehicle to parking lot. On arriving of the vehicle, I shifted a seriously injured person inside the vehicle and proceeded to a civil hospital. And after admitting the injured person in the hospital, I went back to my duty. I do not, in the cross said, I do not know anything about what happened to the injured person and who and how was he injured. So this has nothing to do with this also. Now, my lord, PW3, my lord, PW3 also has nothing to do with the incidents, my lord. And
Who is PW3?
PW3 is a wife of one Crow Cooper Wanyang, who was initially detained, and who is supposed to be the driver of the taxi, my lord. Who was the driver of the taxi?
The lady. It's a taxi driven by a lady.
No. This Srimati Irisha Solang is the wife
Why
of
she
the,
became a witness? Why she was...
that we don't know, my lord. Why the prosecution?
What our deposition says?
Her deposition says that I was born and brought up at Mauritius.
Okay.
So and so. I do not remember the date, year, and month, but I remember that it was Sunday, and I received a phone call from my husband, Crow Cooper, who was driving a local taxi and also used to earn his.
This Crow Cooper was an accused.
He was initially one of the accused, but because the witnesses could not identify him in a test period, therefore he was discharged. Crow Cooper, who was driving a local.
No charge sheet was filed.
No charge sheet was filed against him. Crow Cooper, who was driving a local taxi, will earn his livelihood, mostly to Shillong on that Sunday. I received a phone call from my husband telling me that he is having quarrel relating to some parking fees, in which my husband has not given me the details of the parking lot, in which he is having a quarrel relating to the parking fees. On the same, which is on Sunday, I received one phone call at 10 p.m. informing that my husband has been arrested, but I do not remember now who has made a phone call to me. And on the next date, I went to visit my husband at the Cantonment Beat House. Prosecution has invoked Section 154 Evidence Act for declaring the witness hostile, which is accordingly allowed. So,
No, see, just elaborate us.
my lord.
Now, whether this witness
Yes.
was present at the
No.
scene of occurrence.
No, was
Now,
not
as you
present.
say that her husband was initially thought to be involved in the matter,
Yes.
but then later on, because of lack of evidence, he was not made a charge.
Yes. So,
Now, her role is confined to that telephone call, isn't it? So far
Yes.
as the receipt of the telephone call is concerned.
yes.
Apart from that, now why this witness was declared hostile? Was it
Yes.
something like that she stated something else in 161 statement?
No,
And-
no. 161 statement, no, nothing. My lord, husband informed the wife that we are having some quarrel with some people here. That's the only thing. And subsequently, my lord, in the
That is all right. She proves only that thing.
yes.
So far as the
they're
telephone
having
call
a
is
quarrel.
concerned.
Yes.
But then you see, like this telephone call has nothing to. You see, like it apparently
yes.
doesn't link the accused with the commission of the crime, isn't it?
Yes.
Now, what basically why this court is putting in question is that this witness was declared
Hostile.
hostile.
Yes.
And the court has accepted that, isn't it?
Yes. Yes.
Now, what for she was this hostile? What
My lord-
was the expectation of the prosecution? That like what is the line which the prosecution wanted her to make a
Yes.
deposition?
So that one, my lord's query will come in a cross examination of PW3 by the prosecution, just below the line, my lord, after declaring her hostile.
Yes.
It is not a fact that the police has seized the mobile of my husband Shri Kraukopar Wanyang from my possession. It is a fact that the mobile of my husband, which was seized by the police from my possession, was handed to me by Louis Dotodong. Exhibit 1 is a seizure list dated, and Exhibit 1 by 1 is my signature. On being shown to me today in court, the mobile handset Exhibit 1 I do not recollect whether it was the same mobile handset. I do not know the person Louis Dotodong by face. I only met him once in the court at the court premises. So I do not know the person Louis. So the allegation of what the prosecution wants from here is
No, we do not know. See, anyway, this is very. She says that the mobile which was
yes.
seized from her, or the mobile of her husband,
Yes.
which was seized was not from her possession. Then again she says it was seized from my possession as it was handed over to me by one Louis Doughton.
Doughton.
And what is the difference? The fact remains that it was seized from her possession.
It was seized from her possession.
Only thing is that she want to say that this mobile was given to her by Doughton.
Yes.
But
yes.
then the first time she denies that it was not seized
Yes.
from my
So
possession.
maybe probably for this reason that she was declared at
See,
hostile, my lord.
this reading this evidence
Yes,
makes the court confused.
my lord, because
Anyway,
but anyway,
now,
my lord.
just tell us one thing.
Yes.
Now, what relevancy that mobile has so far as the prosecution case is concerned? Which way it is connected?
Nothing, my lord. Because there is nothing allegation that by this mobile the entire episode of fight was recorded. Nothing.
Or some
as
call
such.
was received or something
Nothing.
like that.
Nothing as such.
So there was not an effort, not even an effort by the prosecution
Yes. Yes.
to prove
Yes.
the the contents of the communication which were made through mobile
Yes, yes.
or any recording made through nothing.
Nothing.
No effort.
No.
Even the IO's evidence, nothing, no
nothing
indication.
will come later, my lord. Nothing.
No,
is
so
there.
far as IO evidence is concerned,
Yes.
does it have any reference to this mobile phone?
My lord, as far as
does
recollect,
it prima facie show? Do not add your version here.
my lord, my lord.
Just without giving, just as the fact stands, as it appears, just tell us which way this mobile is sought to be connected with the prosecution study of the case.
My lord, there is no connection at all, my lord. There is no
Even the
connection
IO's
at all.
deposition doesn't connect.
Does not connect, my lord. Doesn't connect.
So what is the purpose of seizing it?
My lord, that prosecution
Only
will have to
prosecution can
explain.
explain.
They have to,
Only the prosecution can
yes,
explain.
yes. Because now, my lord, if I understand that if there was an allegation of the fight being recorded by my mobile while there was a
So
fighting going on,
This court is asking you this specific question because this witness was declared hostile.
hostile, my lord.
That means this gives an understanding to the court that this mobile perhaps contains very,
Some
data
vital-
which are very
Yes.
relevant for the purpose of the
Yes,
case.
my lord.
So it is nothing as such.
Nothing as such. There is
Why,
no.
why this witness was declared hostile then?
Maybe because, my lord, first she says that yes, the mobile is not seized from me. I don't have the mobile.
That she stated in her cross-examination.
Cross-examination.
After she was declared hostile.
Yes.
But
yes,
then, before that,
yes.
we do not know. See,
But then she has very clearly stated that yes, I got a call from my husband that he is having some quarrel with some people there, and then at night around 10 p.m. somebody called me and informed me that my husband got arrested.
any discussion by the trial court with regard to the deposition of this witness?
My lord, there's
There is. And what does it say? You do not have to take, you just refer at the time when you read the judgment. But for better understanding, the court is asking you those questions.
my lord, these discussions are there, my lord, but it's not very substantive discussions, my lord. Where with very not incriminating.
See, Mr. Yovin,
Yes,
you
my
have
lord.
read out, this is the PW3, isn't it?
Yes, my lord.
You have three witnesses, you have reading out three witnesses.
Yes, my lord.
Now, from the evidence of these three witnesses, except
Yes.
for PW2, who was sent to the spot
Yes.
after the report of incident was communicated to police,
Yes, my lord.
other two
Yes.
to this court,
Yes.
of course, subject to what prosecution letter says or subject to what comes in these things, this court has not understood how they are connected with the.
With the case.
Case,
With the
yes.
case, my lord.
Yes, okay, let us go, let us proceed then.
Now, my lord, the next PW4
Louis
is
Doughton is an accused.
I'm
Louis
sorry?
Doughton is an accused.
Louis
Doughton is an
Comias.
accused.
Louis and Comias. So,
Louis,
today,
Louis is the first one. isn't
Louis
it?
is the first one which I've completed, and now we're going for the Comias.
Okay.
Comias. So, PW4, my lord, is one Sri rinsing.
So according to you, this evidence is not relevant to the prosecution case.
This is also not relevant to the prosecution at all,
So
my
far
lord.
as PW3, the court is asking PW3. It is not relevant.
No, it's not relevant, this one, my lord.
Okay, come to PW4 then.
My lord, this is also Shri Rinsing Karsandi. So this is also, my lord, has no relevance at all, my lord.
Who is he? And
Well-
how he is connected with the prosecution case?
He is the father of, he's my father-in-law of Louis Doughton. Is the father of the PW3. Is the father of PW3.
Okay.
So he just said that I received a call from my daughter informing that my son-in-law got arrested. And it says that is the only thing, my lord. And then he says that no, because it's
just we can read. He speaks about Kraukpar Wanyang also.
yes, yeah, Krau Kopar Waneng is his
Just
son-in-law.
read it. You can just read it. It's a very small one.
Yes, I have been residing at Maureng Maunga for the last 28 years. Till that I do not remember the date and the year of the incident, but I remember that it was on Sunday that my daughter Irisha Solang PW3 came to inform me that her husband Shri Kraukupar Wanyang was arrested at Anjali, Shillong. I received the information from my daughter and arrest of her husband at around 10 p.m. and the information was received by her through telephone by some of his friends, and I told my daughter that we cannot do anything now as it is already night time, and moreover my village Maureng is quite far from Shillong. On the next day, my wife Srimati Felista Walang along with my daughter Irisha Solang came to Shillong to inquire more about the arrest of my son-in-law, and I went on my daily work as I am earning my income by as a sumo driver, and I do not know anything about this case.
This is only pertaining to Kraukupar Wanyang, who has not been made an accused.
Not made an
So
accused.
he also has no relevance so
No
far as
relevance.
so far as these two accused are concerned.
Exactly, my
We do
lord.
not know what kind of a prosecution has been conducted.
Yes. So my lord, now kindly look at doctor's examination,
Just
my
let
lord.
us go by. We do not know. These are all wastes of time. We do not know until and unless.
Yes. So my purpose of reading out these evidences, my lord, even though it's not having any relevance, my
See,
lord.
this is a case of conviction.
Yes.
Okay.
Yes.
The normal criminal proposition
Yes.
that innocent
Yes.
proved guilty
Proved guilty, my lord.
is no more attached with you. Here, situation is changed because you are convicted.
Convicted, my
Now
lord.
the burden is on you.
Yes, my lord.
So now there is no presumption that you are guilty.
Yes, my lord. Now I have to
That there presumption of law.
discharge this deserve.
That is no more there with you.
yes,
And now
yes.
we need
Yes.
more important scrutiny of the evidence
My lord, exactly, my lord.
to see whether
Yes.
you are not guilty.
Yes, my lord. So, my lord, because my burden is to
So
discharge.
this BW4 also
Has no relevance at
has
all.
no connection with
No
these
connection,
two
nothing,
accused.
nothing at all.
Now
my
come
lord.
to, let us proceed to BW5. Anything, do you have to read the cross-examination? No.
There's no cross-examination
Okay,
also, my lord.
cross-examination declined.
Now,
But then we do not know,
yes, my lord.
basically these evidences,
Yes, my lord.
which when this particular person was not charge-sheeted, what relevancy it has with the...
Exactly, my lord. Now, deposition of PW5, my lord is a doctor, Dr. Roland Dawn.
Yes.
My lord, he says, I joined the medical profession on 18th January 1986. During 2011, I was posted as Senior Health Officer at the Post-Mortem Unit Office of the District Medical Health Officer, East Khasi Hills District, Shillong. In this case, I had conducted the post-mortem of the body of late Rigid Kurkarang.
Victim. Victim in
Yes,
this
he is
case.
a victim, 30 years old, son of so-and-so, resident of so-and-so. The body was brought to the hospital at 6:30 p.m. and morgue on 20/03/2011 at 7 p.m. and the examination was conducted on 21/03/2011 at 12:10 p.m. The body was identified in a morgue by S.I. P.K. Singh Cantonment Beat House so-and-so, brother, and number 2, Babyangjit Kurkalang, brother of deceased number 3, G. Nonkandri, stepfather, and number 4, Balajit Nonkandri. The body was in rigor mortis. Height is 5 feet 3 inches with a tattoo mark on the right upper arm tattoo of a dagger. Wounds on the body. There was a bruise on the right eye. There was a punctured stab injury wound 2 by 2 into 0.8 centimeter on the back, 12 centimeter from the neck midline below the scapula, and there is another stab injury 4 into 1 centimeter, 4.2 centimeter above the left nipple and bruise running around the wound. Deep abrasion lateral side of the knees 3 into 5.1 centimeter and another injury abrasion 2 into 1 centimeter below. The knee laterally and another injury laceration 2.5 into 0.5 centimeter parietal vision. The wound is already been stitched. Another injury laceration of so and so cheek side of the nostril. Examination of cranium canal, skull and vertebrae, injury, laceration, scalp 2.5 into 0.5, another injury, depressed, fractured of left parietal bone, so and so. Examination of the brain and the spinal cord, hematoma on the left cerebral hemisphere, partial region, blood stain, cerebrospinal fluid. In my opinion, cause of the death was due to head and chest injuries. Exhibit 2 is the post-mortem report prepared by me, and Exhibit is a signature. Cross-examination now, my lord.
Any weapon seized in this matter?
No. No weapon seized.
No
now,
weapon seized.
now it says there's a punctured, it must be with sharp object.
No, even the very first, you do not have to come to this, even the first paragraph of the description of the injury.
Yes.
Okay.
Yes.
That is where it was a punctured stabbed injury.
Yes.
Now,
Yes.
these are all can be done by instrument, isn't it?
Instrument, my lord. It's
So, there no weapon was seized.
no weapon was seized. my lord. And to this point, what did the learned court said is, when the ocular witness is there, seizing of the material, the weapon, the murder weapon, it's inconsequence.
Please say it again.
What the learned court said was, when the ocular witness is there, ocular witness, my lord has seen ocular witness PW1. When ocular witness is there, is insignificant whether you seize.
It's not totally insignificant, but then may not be damaging. But court says correct. Merely because the weapon
Yes,
of crime
crime
would
was
not be seized,
seized.
it doesn't mean the prosecution case will become fatal case. You see, even non-recovery weapon
Yes,
may not be that fatal if the version of eyewitnesses are reliable.
but then
That is what the law is.
yes, yes,
It's not that is promulgated by Supreme Court.
yes,
Just because no weapon is seized,
yes.
this cannot be a reason for discarding prosecution case.
Exactly, my lord.
We understand, but then that is only in situation where there are availability of good number of or good quality
Good
of
quality of
eyewitness.
Yes, my lord. I was just reading one case, my lord. Of course, there was a firing and some people died, and also in TIP where there. Of course, in that weapon was no seized, but the bullet marks. It says that. That is all, my lord.
Let's see, there you will find many judgment by the Apex Court
Yes.
where the conviction has been upheld, though there was no seizure of weapon.
Yes, my lord.
Okay. Now these are in cases where the evidence adduced in the court,
Yes.
you see, like
It's-
conclusively showed
Yes,
that the accused were
unshakable and
punished. Anyway,
conclusive.
till now we are in a different thing.
My lord.
Now see, okay, so far as the doctor's evidence is concerned, it's clear that the injuries were caused because he says this that in my opinion cause of death was due to head and chest injuries.
Chest injuries.
So chest injuries is caused by stabbing thing. So this one thing is sure that those were the injuries were caused by some weapon.
Some kind of weapons.
So
Some
that has
kind of
not been
weapon.
seized.
Yes, yes, my lord.
Now let us come.
Now, in the cross, what he say was, I cannot say how many hours the disease died, but the post-mortem was conducted within 36 hours.
What does it mean?
I cannot say how many hours the disease died,
What does
but
it
the
mean?
it seems to say that I cannot say exactly at what time the disease died, but the post-mortem was conducted within 36 hours from the time he died. I could not say whether there is any sample of alcohol in the victim's body. The penetrating injuries in the chest may have been caused by sharp weapon. On the side of the head, injuries was caused by some blunt weapon. It is a case of unnatural death. So that is the only thing, my lord. Now, but then again, my lord, this nowhere points a finger to the overt act of the
See, medical evidence
yes
can tell you the cause of death,
yes
but then can never tell you who is the perpetrator.
my lord.
So-
The cause of death is now
We must know the
Yes.
limits of, you see, like
Yes.
a witness will come with the limited things.
yes, my lord.
You can
So
depose only what.
what is there with, as an expert? So there is no quarrel to this, my lord. There is no quarrel to this. Now PW3. Now this is a PW3 is also another doctor, my lord.
Yes.
PW3 is the.
PW7, not PW3.
Oh, I'm sorry, PW7 is another doctor who conducted, who examined the complainant.
Complainant.
The complainant, my lord. Because, my lord will remember, they said my brother was beaten by PW1. The deceased brother was assaulted.
But then we are not concerned with that.
We are not
charge.
concerned with that one, but
We are not dealing with, if see, like
Yes.
if he was beaten,
yes,
he is not made a victim in this case.
my lord.
Isn't it?
Yes, my lord.
There is no charge framed
Yes, my lord.
against the accused
Yes,
for beating the complainant, isn't it?
yes, my lord.
They have been tried for murder of the,
Murder of the deceased, my lord.
not murder, culpable homicide.
Culpable
not a
homicide,
murder.
my lord.
Yes.
So, my
So
lord,
anyway, so this is the, so any requirement of going to this evidence?
my lord, this may not be required, my lord,
No,
because
it's up
since-
to you. If you want to show something, you can show. But then otherwise, we are not concerned with that part of the evidence.
my lord,
But
let
he
us.
saw that the brother of the deceased were beaten. We have nothing to do with
Nothing
it.
to do with it. My lord, let us go to PW8, my lord. PW8 is the magistrate, my lord,
Yes.
who have taken 164 statements, my lord.
Of
164 statements, my lord, of all the witnesses, my lord.
how many witnesses were examined under 164?
Let me just check once. Exhibit one, just one. Only two witnesses were examined by him, my lord, by her, my lord.
Who are those witnesses?
PW1 and PW9, my lord.
Just a minute. Now, whether PW1 was asked about any statement given by him in his evidence, has he exhibited his evidence 164 statement before the court in his deposition? PW1. If you say that PW1 was
Yes, my lord.
examined
It is
under 164,
164, my lord. Just give me the page number. 164. Page 50 and page 56 are the depositions, my lord, or under 164, my lord.
see, 164 is not a deposition, this is statement.
I'm sorry.
Please,
The
please see,
statements,
See what the court is asking. Kindly understand.
my lord.
When 164 statement is recorded,
Yes, my lord.
164 statement of a witness is recorded,
Yes, my lord.
this court is asking you the question whether that 164 statement was exhibited by the witness while his deposition was recorded at the trial. Mr. Even these are vital questions.
My
You are
lord.
not supposed to look here and there for answering this.
My lord, just going through this statement. My lord, my lord, may I?
Whether this 164 statement
Yes, my lord.
of these two witnesses were exhibited before the court,
Yes.
before the trial court, who exhibited it?
My lord, the magistrate has exhibited, my lord.
So the question is that the giver of the statement has not exhibited.
No, they have not exhibited. The magistrate has
so far
exhibited.
as the correctness of 164 statement is concerned,
Yes.
the witnesses were not asked about all those things.
No,
isn't
no, it was not
it?
asked
So
about
these are
that.
all very vital points for you.
My lord, just because here the magistrate
Anyway,
exhibits.
let us see. So this is whether, and let us finish. This.
My lord, let us read this one, my lord.
this is
PW8.
PW7.
PW8, my lord, the magistrate. Page 68, my lord.
Yes.
It said, I have received someone to appear before the court today. In the year 2011, I was posted at Shillong as Judicial Magistrate First Class at Shillong, and present I am posting as a Chief Judicial Magistrate Nongpo. I am aware why I am summoned to the court today, and I am also aware that I had recorded the statement of witnesses in the instant case. The witnesses whose statement I had recorded were the prosecution witnesses. Exhibit 5 is a statement recorded by me of witness Sri Sylvester Kongsit. Exhibit 5 by 1 is my signature, and on the reverse page of Exhibit 5,
Who is this Sylvester Kongsit? He is PW.
PW1 is a PW.
But then in his statement, PW1 in his statement has nowhere said that he was examined at a 164.
No, he was.
Yes.
To the best of my recollection, the deposition made by the witness was made in Khasi, but I did not need to interpret, as I am well conversant with the Khasi language. I have recorded whatever the witness has stated before me. Exhibit 6 is a statement recorded by me of witness Babyangjit Kurkalang, and Exhibit 6 by 1 is my signature on the reverse of the Exhibit 6. The witness Babyangjit Kurkalang was a brother of the deceased and also the one who had lodged the FIR before the police. The witness has also deposed in Khasi language, and the same I am well conversant with the Khasi language. Therefore, no interpreter was required. That all I have to say. Cross-examination by defense, my lord. I do not remember the timing, but I recorded the statement during the court hours. It is a fact that the time of recording of the statement of Sylvester Khongsit and witnesses did not know the name of the accused. At the time when the incident had happened, it is a fact that witness Sylvester Khongsit did not give the physical description of the persons involved, but had stated that he saw one of them carrying a hammer. The witness had only mentioned the date but not the time, and had also stated that at the time of the incident he was collecting parking fees.
What this magistrate has to do with the contents of the statement? This is not a statement given by the magistrate.
Yes, my lord.
So the fact stated in that statement,
Yes.
has to be proved
Yes.
by the person who gave the statement.
Who gave the statement, my
So this
lord?
is
Exactly.
what value this statement will have. This
Nothing,
will
my
come
lord.
in kind of hearsay statement.
Yes, my lord.
Cannot be accepted in law.
Cannot be accepted, my lord.
We
So,
don't
my lord,
know-
now
you see, like the in manner which prosecution has conducted this case.
now, my lord,
Please take note, Mr. Guru. This will be your duty to correct those aspects. You should make sure that nobody escapes because of the.
Absolutely.
Till now, the manner which this evidence, manner in which it is recorded, note which is things, this court doesn't find very impressive. You should take note of the thing, please.
Now-
PW9 will be very vital.
That is the
PW9.
only thing. Let us see till now.
Now PW9, my lord.
we'll hear you.
PW9 is now we are coming to PW9, my lord.
Is the brother?
Is a brother. He is a complainant, my lord. His name is Babyangjit Kurkalang, my lord. On oath, my lord has got
What is page?
page 69, my lord.
Yes.
Now, I have received someone to appear before this court today, and I am also aware as to why I have been summoned before this honorable court. The instant case is with regard to the murder of my brother, led Rijit Kurkalang. On 20th March 2011, around 2:30 p.m., while I was collecting the parking fees at Anjali parking lot, I saw two boys sitting in a local taxi consuming beer. I asked for the parking fee from them, but they refused to give any. Since these two boys were refusing to give the parking fee, I called my brother Rijit Kurkalang, late Rijit Kurkalang. After some time, my deceased brother came to the spot, and we had a quarrel with these two persons who were not paying the parking fee. And after some time, both these persons left the place, leaving the local taxi at the spot. Later on, after some time, these two persons came back again, along with other people who were armed with hammer, iron rod, dagger, and assaulted us. And out of fear, I managed to flee away from the scene. But these people continued to assault my elder brother, and after assaulting him, they fled from the place. After I have fled from the place, I went straight home and informed the relatives, and later on, we were informed that the police had reached the spot and saw my brother, who was badly injured, and took him to Civil Hospital Shillong for medical treatment. But unfortunately, later on, he succumbed to his injuries on the same day. Later on, we received a phone call from our friends who were working as parking lot attendee, and they told us that my injured brother has been shifted to Civil Hospital Shillong by the police. And on receiving the said information, I, along with my relatives, immediately rushed to the Civil Hospital Shillong. And when we reached Civil Hospital Shillong, he was bandaged and was conscious, but later 10 to 20 minutes, he succumbed to his injuries. Later on, I had lodged the FIR to the police at Cantonment Beat House. The FIR was written by then in charge, Mr. Singh, on being narrated by me. And after being satisfied, I had put my signature on the FIR. Exhibit 5 is the FIR lodged by me, and Exhibit 5 by 1 is my signature. I also remembered I was also asked to identify the accused persons, and identification was conducted at District Jail East Khasil, Shillong, and the same was conducted at in the presence of one magistrate. In the said test identification parade conducted at the jail, I was able to identify both the accused persons, and these two persons are also present in the court today. Witness point out to both the accused persons who are standing in the courtroom today. Exhibit 6 is the identification of suspect report. 6/1 is my signature. I do not remember whether my statement was recorded by any magistrate since it has been so long. I had drafted, now in the cross-examination, what did he say? I had drafted the FIR. I went alone to the police to lodge the FIR. I am working as a parking attendee. On the day the incident had occurred, at that time we charged 30 rupees for whole day parking vehicle. On the day of the incident, I had asked the parking fees from person who is also present today in the court, since he was sitting in the vehicle, and there was also another person whose name I do not know. I do not know whether Komias Notodong was a passenger or a driver, but he was sitting inside the vehicle. Suggestions. Counsel suggested that as per the statement of serious grievances during the cross-examination, he had stated that you, deceased brother, were drunk. He answered, I do not agree to the said statement since I and my brother were not drunk on the day of the incident. It is a fact that there were many people who had assaulted me. It is fact that there were many people who had assaulted me and my brother, but I also like to state clearly that the two accused persons who are present today in the courtroom. At that time of the incident, my elder brother was at Foreign Market, Bara Bazar, Yodo, and I went to call him from there. It is not a fact that I had stated today is what I've seen happen to us on that day. It is not a fact that I was in the custody at the jail at the time when the TIP was conducted.
Yes.
Now, my lord, leaving besides the crux, what he said, he saw and he didn't see. This, even the small fractions of his statements cannot be relied, my lord. Number one, he said, I saw the two persons taking beer, my lord. When we were arrested, we were medically examined. In a medical examination, I can show that, my lord. It says that there is no alcohol content, number one. So in that aspect, he was wrong. Having consuming, it was wrong. Second part, he says that.
No, which medical report says that there was no alcohol?
Yes, I'll just point to that.
And what time he saw you consuming beer, and what time your medical examination was conducted? Your medical examination was conducted only after arrest, isn't it?
Yes, my lord, 41. That is on the same date, my lord, 41. Page 41.
Date, okay, but then after how many hours? Then tell us how long alcohol remains in blood.
My lord, this medical exam.
If you have to base your case on that,
yes, my lord.
You have to make us understand those. That alcohol, if you take, how long it will remain in your blood?
My lord, they said this incident had happened around 2 p.m. This incident had happened around 2 p.m. And, the place of the incident happened around 4 p.m., my lord. And we were arrested 1 hour, about 5 to 6 p.m., my lord. After that, we were on the same day, on 20th of March 2011, we were taken for examination of.
What time you were taken for medical examination?
Just find out.
And he did not say that you were consuming beer at the time of the incident. He said that you were consuming beer at the first instance, before you left to bring your party.
So, my lord, this is, but can you look at the medical report of the accused? Just check the medical report of the I'll come back.
It's all right. It's all right.
I'll come back to this.
Next point.
I'll come back to this point again. My
Because
my
since you are
assistants
trying to
will.
dislodge
Yes.
some prosecution evidence,
Yes.
so that is why.
And the second point why he's not reliable, what I'm trying to say is he was not very truthful in his deposition. Is he said that he and his brother were not drunk on that day. Now his friend PW1 very clearly stated, Melody, if I'll just read out from.
But then which way it will make a difference?
No, what I mean to say.
Whether he was drunk, he was not drunk. What
Yes.
matters is that
Yes.
the evidence which he has given.
Yes.
Now, which way you disclosed it? That is the main thing.
Well,
At that moment, when the incident happened, whether
Yes.
he was drunk, he was not drunk, if you can prove that yes, he was wrong, he was drunk and he said he was not drunk,
so what?
that also basically will not enough to disclose the evidence which is adduced before the court.
Yes. So what I wanted to build up from here is, my lord, number one thing is that, my lord, his statement, even in the very small statements that he's making, is not truthful, my lord. Second part, what he said that he was not drunk. First of all, what he says that we were consuming beer, that has been negated by the medical report of the accused person. Second part, he said he and his brother, the deceased, were not drunk. That also been negated by his own friend, PW1, who says that both the brothers were drunk. The third point, what he said in this evidence himself, he says that the FIR was written by one officer in charge, KP Singh, who was on his instruction. And in the cross, he says that no, I drafted the FIR. So small bits, my lord, what I want to say, the reliability of this person, my lord, a very fickle.
See, mere inconsistency
Yes,
may not be good enough to interfere.
it is not.
See, until and unless there is a contradiction.
What I want to bring home the point here is, made this witness, number one, he is emotionally charged. He is emotionally charged. Why? Because he lost his brother. Now, second point, he's very fickle-minded, because all the statements that he is giving before the police, be it a very small bits, my lord, it may not have any much substance to the core issue here, my lord. But the mind of this witness, my lord, whatever he is stating has all been negated, my lord. Therefore, what I want to bring home is, how much can you rely on this kind of witnesses? This is the point that I wanted to bring it home, my lord. How much can you rely on this kind of witnesses who keeps on changing his statement at the blink of an eye?
Where is the change of statement? How many sorts of statement he has given?
Here, my lord, whatever three statements that I've shown, my lord, it's just one who negated.
Three statements means where?
The three depositions, the statement he has given before the court. Number one, that we were drunk. Medical examinations, that there's no found in alcohol in our body, no alcohol. Number two, he said that he and his brother were not drunk. His friend PW1 says that they were drunk. And number three, he says that no FIR was written by KP Singh. In the cross, he said no FIR is written by me, drafted by me.
What difference it will make if we accept those what you say?
If we accept what we
So
say,
you will
this,
say the very reliability of that person will.
yes.
Okay.
So this is what I wanted to emphasize here, my lord. Now, my lord, he said there were a group of people. There are a group of people who came and assaulted, armed with this thing. And he said, I got scared and I ran away. His statement, he said, I got scared and I ran away and I informed the house. So how did he witness? Which witness has hit his brother? Now, after building up his reliability, I'm coming back to hitting the core issue, my lord. He's saying, I ran away. It is his statement, not my statement. He said, I ran away. How did he witness then? So how did this become ocular witness then? So therefore, my lord, even this PW9, who is supposed to be the star witness of the prosecution, my lord.
Yes, except for this PW9, there is no other witness.
No other witnesses, my lord.
And then
now, my lord, PW10, PW11, my lord, we can skip. These are the officers who have just forwarded the charge sheet. They're the officer in charge, my lord, Inspector Prashant
Yes.
My lord, we'll skip two of the witnesses, my lord, because these are the officers who just forwarded the charge
Which
sheet.
two witnesses?
PW10,
Okay.
PW10, who did the GD entry and all this thing is okay, my lord. And PW1, Malap, again he is the OC who forwarded the charge sheet to the court. So this,
So that
Yes.
not much relevant.
yes, my lord. So my lord, now important is deposition of PW12. He is the IO of the case, my lord. He is the IO of the case. His name is Malab Kamlesh Prasad Singh.
Yes.
He is Sada police station at that point of time. So, may I read, my lord? On oath. In the year 2011, I was posted at Cantonment Beat House as in charge. I am the IO of the instant case. The case was reported to Cantonment Beat House on 20th of March 2011 on the same day, that is about 2:30 p.m. And it was a holy. Three persons, namely Kraukopar Wanyang, Cornelius Dotodong and Louis Dotodong of Mao Syndrome and Maungap appeared at Beat House and verbally reported that the vehicle Tata Indica bearing registration number so and so was damaged by some people and all of them were assaulted by many people. Accordingly, they were sent to the civil hospital Shillong for medical examination and the head constable M.N. Sangma, who was on patrolling duty in Maulanghat area, was directed to take care of the damaged vehicle. On arrival at the spot, the head constable informed me that one injured person is lying near the damaged vehicle. Accordingly, the injured person was shifted to civil hospital Shillong for medical examination. The first parties who were sent for medical examination to civil hospital Shillong returned back to Beat House and a medical report was produced which shows a simple injury on their body. The damaged vehicle bearing registration was seized and brought to Beat House. The first information FIR was filed by Kraukupar Wanyang regarding the damaged vehicle and a separate case was registered under section 427/322 IPC and it was registered by Shillong Sada PS case number so and so. While the process was going on, at about 6:10 p.m., I received a telephone call from police assistant booth, civil hospital Shillong, that the injured person Sri Rijit Kurkalang, who was admitted in hospital, succumbed to his injuries in the hospital. Then I rushed to civil hospital Shillong and kept the three persons at Beat House. On arrival at civil hospital, I found a big crowd as the deceased was a member of the Khasi Students Union. I conducted the inquest over the dead body and found some repair wound injury mark on the left side of the chest and head of the body was forwarded to SDMHO Civil Hospital Shillong for doing post-mortem examination. I had also prepared the inquest report in connection with the instant case. Exhibit 8 is the inquest report dated so and so, I prepared by me, and Exhibit 8/1 is my signature. I returned back to Beat House and the first three persons who were detained at Beat House, I found only two, Komias Dotodong and Kraukupar Waneng. After some time, one of the eyewitness, Sylvester Khongsit, appeared and identified Sri Komias Dotodong as a prime accused, and a written FIR was filed by Babunjat Kurkalang, brother of the deceased, and in this instant case was registered by Shillong Sada PS case number so and so, and Sri Komias Dotodong and Sri Kraukupar Wanyang were arrested on the same day and forwarded to the court on 21/03/2011. During the course of investigation, one mobile phone with two SIM cards were seized by me on being produced by Unisha Solang, wife of Kraukupar Wanyang, and the same were seized at a Beat House. The name of the company of the mobile so and so. I also prepared Caesar list. On being shown Exhibit 1, I can identify my signature on being Caesar. I also visited, see, now my lord, he never said the contents of the mobile here. He just said I seized. I had also visited the place of the occurrence while seizing the vehicle, and I had also prepared a sketch map at the place of the occurrence. Exhibit 9 is the rough map prepared by Exhibit 9 is my signature. Post-mortem was conducted on 21/03/2011 and the medical officer had also handed over some blood sample to FSL opinion and the body was handed over to the family members for completion of last rites. At the time of the handing over the body, I had also prepared a dead body handover certificate which was accepted by Babiangjit. Exhibit 10 is the dead body challan while sending the body to post-mortem examination. Exhibit 10/1 is my signature. Exhibit 11 is the dead body handed over certificate. The statement both the accused was recorded under section 161 CRPC and the statement of witness as well as the complainant were also recorded. The complainant was also assaulted at the time of the assault. The accused was re-forwarded to the court. That expiry of police custody during the course of investigation, I have seized the wearing apparel of the deceased victim, a black jean of being handed over by the doctor. I have also prepared a seizure list while I have seized the black jean pant and a blood sample on being handed over by the doctor of civil hospital. Exhibit 12 is a signature. This is so and so. On 1st April 2011, I received a copy of the court order passed by Honorable District stating that the accused had produced pre-arrest bail and the court has directed him to appear before the undersigned, but he did not comply with the court order. Accordingly, a lookout notice was issued against the accused Louis. During the course of investigation, TIP was conducted at the jail premises and the same was conducted on 7/4 at the jail premises where the witness Babiangjit and Sylvester identified Cornelius Dodong, but Kraukopar could not be identified. On 6/4/2011, the mobile set seized from the Dodong and the same mobile was used by accused Sri Komias. Exhibit 13 is a seizure, so and so. During the course of the investigation, accused Louis, in compliance with the order passed by the District Council Court, had appeared before me on 6/4 and I have seized one mobile phone from him and later on I had also served a notice to appear for the TIP on 7/4 to be conducted.
Just a minute. Coming to the TIP part.
Yes, my lord.
Now, this, so far as the report of the TIP is concerned, that is not exhibited.
My lord, before he proceeds, my lord, actually, my friend is, my lord, indicating that there was only one TIP. There, two TIPs were being conducted, my lord. One is missing from the paper book. That is what I am saying.
No, but then we are asking that whether it was exhibited or not.
My lord, as per the judgment reflects, my lord, it seems.
No, but then where it is there in the evidence? Judgment cannot take something in consideration if it is not exhibited in evidence.
That is there, but
Now,
however.
this court is, see, what is basically just see, read out that paragraph again. The during course of the TIP, so Mr.
Yes, my lord.
You don't
During the course of the investigation, accused.
Course of investigation, TIP was
TIP
conducted.
was. During the course of the investigation, TIP was conducted at the jail premises and the same was conducted on 7/4/2011 at the jail premises where the witness Babiangjak, Kukarlang and Sylvester identified were callers, but Kraukopar one could not be identified.
Now, where is the report of the TIP then?
The report of the TIP, my lord, I have submitted on last occasions, but
No,
that
where
is
it has been exhibited?
exhibit is not.
not exhibited.
I could not find the exhibit. It is, of course, it is there.
Is there
out of the
any
court.
mention in the evidence of any witness that it was exhibited?
It is not mentioned by either by Sylvester Kongsit nor by PW9.
Then who? No, whether
Even the
whether
IO.
this IO has.
No, even the IO is silent on the TIP exhibition
Is
of
it
the
correct?
TIP.
Exhibit 6 is a statement under 164.
Yes,
That
my
is
lord.
by the magistrate.
Magistrate, yes, my lord. So, my lord, that is why in my written argument also I have stressed little more on the TIP, my lord.
But that is all right. But then we want to.
Exhibit 6 is the, my lord, the first TIP. Because at that point of time, my lord,
What is come to the deposition of the magistrate?
Page 150.
That is PW what? That one?
That is PW
8.
PW8, my lord. Exhibit 5 is a
See,
statement.
exhibit 6 is the statement recorded by
Statement,
me.
Yes, my lord.
We are
How many exhibit 6 are there?
Now event the TIP. There's one of the witnesses. The TIP was examined. TIP was conducted in the presence of a magistrate. Now, which magistrate? That also not met a witness.
These are all become grounds. But then first we want to see whether the TIP was made this thing. The report of the test identification was exhibited or not. If it is not exhibited, then how could magistrate take cognizance of that? Because magistrate was not present there.
Yes.
At least the judge.
Yes, my lord.
So
Yes. Therefore, my lord, now
you have never said that this was not exhibited.
My lord, page 69, the statement of PW9, it speaks of Exhibit 6, that is the test identification.
Exhibit 6 is the statement of the recorded by the witness.
Kindly see, my lord.
So how can there be two distinct
Exactly.
exhibits?
Page 69, my lord, in the middle paragraph. Exhibit 6 is the identification of the suspect report. Exhibit 6 by 1 is my signature.
So how many exhibit 6 are there?
That apart, my lord, there was second TIP also, because at that point of time, my lord, when at the time of first TIP, my lord, Louis Dordong was absconding. After he surrendered, then a second test TIP was conducted.
Oh, where is that report and what is that exhibit?
For that, I have to go through the LC record, my lord.
No, you have to then. This must then.
Because this will be.
If these are the basis of conviction, then you have to find it out.
Yes, yes. Sure. Otherwise, it will be misleading, my lord.
Yes, Mr. Rivel.
So, my lord, I come back to the TIP, my lord. So, as my lord, so I'll just carry on from on the 19th, on the 19.4, page 78, the paragraph 2 onwards, my lord. I like to finish the reading part and then give the submissions, my lord. On 19.4/2011.
78.
78, my lord, from paragraph. This is
Yes.
from where I left.
Yes.
On the 19.04/2011, the Honorable Court has asked a report regarding the seizure of the vehicle. Report was received, so and so. On 02/05/2000, I received the copy of the court order issued by, so this also will skip. And 08/07/2011, a copy of the order was received from Senior Government Advocate, High Court, directing me to produce a case diary. Accordingly, the case diary was produced before the Honorable High Court. Now, on perusal of the case diary, the Honorable Court has directed the accused to surrender before the police. Accordingly, on 28/07/2011, the accused Louis surrendered. His statement recorded. He was arrested and forwarded to the Honorable Court on 29/7, and he was granted 7 days police custody. On 5/8/2011, he was re-forwarded to the Honorable Court after expiry of and on 26/08/2011, TIP was conducted in the jail premises, and Sylvester Khongside identified Sri Louis.
This is the second TIP.
Where is that report?
My lord,
Where
government.
is that report?
Yes.
It should have been in the paper book, my lord. So for that, again,
Where it is exhibited? What is the question of these things? If it is treated as exhibit, then it will become a part of paper book.
list of exhibits are there, my lord.
Who has made this list of exhibits and how this becomes
The appellant herein, my lord.
No, just tell us then how it is becoming exhibit. Who treated it exhibit? Can the court treat anything as exhibit?
Yes.
And can the cognizance of those documents be
My
taken
lord,
behind
for-
the back of the accused?
For my lord, quality assistance, my lord, we have to go through the LC record first.
Please
my
do
lord,
it.
because this is not.
But then this is not the manner with
Yes,
prosecution.
my paper book is not complete, my lord. In fact,
My lord, to my most humble submissions, my lord, as a responsible officer of the court, we will not suppress any documents which is not.
Question is not of suppression, Mr. Yubin.
No, because
If
keep
just a
on
minute,
saying-
just a minute.
Yes.
Whether a document has been taken to consideration rightly or wrongly,
Yes, my lord.
leaving behind this issue,
Yes.
once you are on appeal,
Yes.
that it becomes your duty
Yes.
to place on record every document
Yes.
which are reflected in the impugned judgment. Now, have you done it?
My lord has given on the first round, my lord. As I said, my lord, we were having a very limited documents. Anyway, we have filed, and my lord was kind enough to allow us to examine. We have compared.
Paper book is
Yes.
is to be prepared after arrival of the record. If you find something is not there with you, you should get it from here and then you should include it.
So after this, my lord, we have compared with the LC records, my lord. All are included here except for some documents which is not. With the permission of the court, we have filed supplementary charge sheet, my lord. Or paper
So
book, my
that
lord.
means
So-
what Mr. Gurung is saying, that this TIP which is missing is not correct. It means it is there already part.
My lord, it is
Have you gone through the trial court's judgment?
trial court's judgment.
Whether
is-
any reliance has been placed on the TIP report?
Yes, ma'am.
it has been
So then,
placed.
then it was your duty to incorporate it in the paper book.
My lord, on this point, then, my lord, can we resume on Monday, my lord?
See, Mr. Gurung has to reply. So this will, and he wants to go to the record before he addresses the court.
My lord.
In any case, this matter will go to other day. But then only thing is that you see, these are the basics. You see.
Yes.
A hearing should not be disrupted because of the absence of this document.
Yes, my lord.
At the final stage.
Yes.
My lord, page
That was
150.
basically expected of you, that you will take care, you will take
Yes.
note of the trial court judgment
My lord.
and enclose all those
My lord.
documents. Incorporate all those documents in your paper book.
My lord.
My lord,
What is missing?
page 150 will clarify, my lord, of the judgment. Page 150, paragraph 97. If I may read, my lord.
See, for what purpose you are reading it?
Because in the judgment, my lord,
Mr. Yobin has not completed. So
No,
you are
my
not
lord,
supposed to
it
resume your...
speaks of, my lord, both the TIPs, my lord.
My lord.
So that is
page.
what, he is not denying.
Page 9, my lord, page 97, what my learned senior is referring to. It is doesn't say anything about the exhibits that have been exhibited.
Page?
Page 97, which my senior is referring to, page
97.
para 97 of the
Page
judgment.
150. Page 150.
152, yes, 152. Yeah, up, Louis, what are they?
This is a judgment by which court?
Well, this is judgment by R. Rambai, my lord.
Which court? Who is the court?
Additional Session Judge Shillong. Page 152, my lord.
It
has
is
got-
not tried by district council.
No, my lord.
Why? Sadar PS. Is it a Sadar PS case?
This,
Shutter PS, my lord.
yes, my lord. This is
That is the reason. Yes.
97, my lord. Can you look? With regard to the
97
identification.
at page 150.
152. 152. 152.
Yes.
With regard to the identification of the accused person, it is established that the accused Comius and accused Lois were present on the day of the incident and assaulted the deceased and PW9 from the evidence of PW12. From the evidence of PW12, it is found that during the course of his investigation, the TIP was conducted firstly on 7, where PW9 identified accused Comius, and in the second TIP conducted on 12, after accused surrendered, PW1 identified accused Louis. During the recording of their evidence during the court number 1, again accused Louis and were both identified. But now where is the report? As my lord has come down. I am not denying this.
Incorporate from the LC record, man.
What is the question of incorporating? Court has not not referred to any exhibit.
Exhibits, exactly, my
So
lord.
how can we treat it as an exhibit in the case?
That was the query, my lord, that had fallen from your lordship,
Mr.
my
Gurung,
lord.
if you say something, just try to establish it before this.
Because
court.
it is part of the...
It is not that the court should say something, and then if you are placing some point, it has to be on the basis of something.
Because, my lord, during the course of the submission of my learned friend, my lord, he was, my lord, harping on only the
Is
first,
there any list of
first TIP.
exhibits
my lord.
reflected in a separate page in the judgment?
Yes.
Just please take us to that page. Where is that page?
Page is, my lord, 126 is the page.
It's shown that the list of exhibits.
I got a point, my lord. I just
See, normally you'll find in many
Yes.
judgments of trial court, a separate
at the-
page is attached.
yes, at the end of the judgment, my lord, you
Disclosing
normally
the number of witnesses, their name and identities, and the
Yes.
evidences, list of evidences. Any such thing done here?
my lord, to my judgment, my lord, that is not there. Can I see the LC record? Just check the last page of the judgment. You normally they.
So, but then it is in your paperwork, it is not there.
It is not here, my lord. We have
It's okay, no problem then. It can be at the last, it can be at the beginning also sometimes. Now, how do we say that these are exhibits or these are not exhibits?
Because, my lord, if they have been exhibited, then the person who
Overlooking this point, you have travelled beyond. You have addressed the court on the issue that TIP cannot be
sole
treated-
ground, sole ground.
cannot as a substantial piece of evidence.
Yes, my lord.
It can hardly be supporting evidence.
Yes.
But
Now,
then, at least the TIP should be placed before the court. Where is the TIP?
the TIP.
So you have not
yes.
taken that point. You have overstepped it and then gone further. Some other things.
No,
This should have been the primary thing which you should have raised.
Yes, my lord. Now coming back, my lord. In the course of the argument, my lord is right. I have travelled to that point. Actually, I need not travel that point only because you have convicted me based on the TIP which has not been exhibited, which has not been
So
challenged.
you just say
Yes,
the court has placed reliance on something
on something which has
which is not part of the record, and that strikes
that is the
at the
Yes.
very root of the thing.
Yes,
the
my lord.
exercise
I-
of jurisdiction.
my lord. I am humble.
It's
my
a,
lord.
it's a kind of a erroneous exercise of jurisdiction.
Exactly, my lord. So page 97, paragraph 97 itself is so erroneous, my lord. So in any way, my lord, I'm coming back, my lord. I'm like every day is learning for us on the course, my lord. It's like,
No, see,
of course we.
everyone learns. It is not
Yes,
that
my lord.
everyone learns.
Yes,
Then,
my lord.
You see what happens, like you proceed. You see, like take steps like 1, 2, 3, 4. It is not that from 0 you jump to 10 and from 10 to 20.
My lord. My lord.
Move gradually, isn't it?
My lord.
So that is what.
This
Before
non-exhibit.
you come to the admissibility of
Yes.
and the reliance of the TIP, you first say that whether it is properly exhibited or not,
My lord.
and whether court was proper to take cognizance of that,
Call me, my lord. My lord.
without saying being exhibited.
My lord. My lord. With a very.
Now you will find this the interesting part
Yes.
is that here in the course of evidence 164 statement of 2 witnesses were recorded, but then both the
Were not exhibited.
they did not say even they did not
They
even
don't-
disclose
Yes,
that
my
I
lord.
was examined by Magistrate.
Yes, exactly, my lord.
Now thereafter what value that 164 and the evidence of Magistrate will have, that is one question.
Yes.
Second thing is the TIP,
Yes.
which according to you is the main basis for conviction.
Yes. Yes.
Now, apart from being what you say on the question of law, the admissibility of TIP and whether it can be
Yes.
treated as a substantive evidence or not,
Yes.
these statements were never made available. The identification period report was
Yes.
never made available to the court.
Yes. Yes.
Now, even for conducting TIP,
Yes.
there is a procedure prescribed perhaps in law.
Yes. Yes.
Now, how do we say that those prescribed procedures were followed?
Followed or not, my lord.
Now, and how TIP was conducted?
Yes.
The IOS evidence doesn't say so.
No.
Well, Mr. Gurung, don't mind. The court is not arguing a case for the defense.
Perfectly all right, my lord.
Not court necessity.
No, my lord. My lord.
But then we are saying that
Yes.
TIP is normally done by keeping accused in one line
Yes.
and
Yes.
the identifier hidden.
Yes.
My
Yes.
Okay?
My lord.
Just basically he is allowed to peep through a hole and identify.
Yes.
Whether that practice was followed here, is there any evidence? No.
Nothing.
So
Nothing.
that strikes at the root.
Yes, my lord.
There is no proper identification.
Yes, my lord.
You can well say, even if the prosecution say that there is identification, it is nothing. It is one-to-one identification.
Yes.
The accused was kept here and the witness was here.
Yes.
And
yes.
easy yes,
Yes, he is the one. Now,
there is no evidence to show that how many persons were standing in the queue
yes.
in the test identification period.
Because now, my lord.
It is
Yes.
nowhere there in the evidence.
It is no evidence at all, my lord. Now, on the basis of no evidence at all, my lord, convicting the accused persons, my lord, is the
Let us see
appellants.
the judgment of the trial court. What are the main basis of the argument?
My lord, before that, my lord, at the time of conducting the TIP, my lord, kindly see page 99, my lord. The requirements
What is that?
for my lord, property.
99 is what?
Page 99 is the TIP.
Where from it comes?
In the paper book, my lord.
Yes, but then how do you take cognizance of that?
Exactly, my lord. So far the query of your lordship, my lord, whether all the, my lord, guidelines.
Provided this document becomes admissible.
Exactly.
That is what.
Exactly.
You first saw it can be admitted. not being this thing exhibited by any of the witness.
So, what I could understand was, my lord, what fell from your lordship was that whether all the, my lord, measures were being adopted at the time of TIP.
See, that is in absence of
Exactly. So far as reliance, my lord, my lordship is
absence of
absolutely correct.
availability of the
My lord.
test handling and report
Yes,
to the
yes,
court.
yes.
Now, whether IO has deposed, the manner and mode.
Absolutely correct.
There are two things, Mr. Gurum. One thing is to exhibit one document,
Exactly.
and another thing is to prove the contents of the document.
Exactly, my lord.
So
The document may be
prosecution's-
exhibited, but the contents
prosecution
thereof
dis-
has to be proved. my lord.
Prosecution duty is not absolved just by exhibiting a document.
Exactly.
It must prove the contents.
Absolutely, my lord. Even in POCSO matters, my lord, where the birth certificates are being, my lord, exhibited, but the contents thereof has to be, my lord,
Exactly.
in a different way.
At least it happens in every case. You see,
Exactly.
The basic principle of this thing is.
My lord is absolutely.
Now, my lord, to add further salt to the injury of the prosecution case, page 80. Can you look at page 80, the last
Page 80.
page 80, my lord. Page 80, the third last paragraph onwards, my lord. Page 80, the third last paragraph onwards. Page 80, my lord has got the third paragraph on. It is a fact from there. It is a fact that TIP was conducted in connection with the instant case. The
Page
TIP
80.
80, my lord. 80.
This is a deposition of part of deposition.
IO. This is a cross of the IO, my lord.
It is a fact
so
that
the-
TAP was conducted in connection
Yes,
with
it is a fact that TIP was conducted in connection with the instant case. The TIP was conducted in jail premises in the absence of the IO.
Okay.
Number one. Second, I do not know if one of the witnesses who had identified the accused while conducting TIP was lodged in judicial custody at the district jail at the time of conducting TIP.
So the TIP was conducted in absence of IO.
In the absence of IO.
So we take it as in the both the cases of TIP. There are if it is to be assumed that there are
Assumed.
Now,
So,
second thing, this is a deposition of IO, isn't it?
yes, it's an IO. IO is saying this. So he is investigating and he is not present.
So what you will say, what you will tap in so far as his evidence with regard to the TIP is concerned, what you will say it, which way?
So now, my lord, he is the investigating
See,
officer.
it is not that if IO was not present at the time of conduction of TIP,
Then who said?
that means he is not saying anything on the basis of his knowledge.
Yes.
So then his deposition has to be on the basis of a report. That means on record.
Or report. And
Isn't
whose
it?
report?
The officer who was present at the time of
Yes.
at the time when TIP was conducted.
And now
And then after perusing the report,
Yes.
he finds something, then he comes and deposes.
Yes.
So there is nothing on this.
Yes. So now,
Anyway, let us come to the judgment. You have pointed out enough.
and one more, just one more page 81, my lord. Just one more
Till
page.
now you are not satisfied.
No, I am
Yes.
satisfied, my lord. Just one more, my lord. Just one, my lord.
Yes, please.
During the course of investigation, since
Which page?
witnesses
Which
were
page? Which page?
page 81, my lord. Page 81. Page 81.
Have you taken all those points in your notes?
My lord, it's
These are all this thing.
yes. 81. First paragraph itself, my lord. During the course of the investigation, since witnesses were not able to identify accused Kraukopar while conducting TIP, hence finding no evidence, I had not charge sheeted the accused Shri Kraukopar warning in this case. So, my lord, first of all, no evidence at all. TIP was not exhibited. Let's say, even if TIP was exhibited, just assuming for a moment, my lord, the prosecution case was solely based on TIP, my lord. Just assuming for a moment, then that also is not sustainable in the eye of law, my lord. In the criminal jurisprudence is convicting a person without a substantive evidence, my lord. It's erroneous, my lord. Now, my lord, judgment, my lord, I will take directly to para 98, my lord, because the front discussions are only from here. Para 98. Discussions, my lord, page 145. page 145 of the judgment, my lord, discussions and reasons. Discussions and reasons. Because the front part is who said what we have just read, my lord. There's a discussion of who said what and all this, my lord. Now, we can skip, my lord has got page
145.
145, my lord. Under the
Yes.
paragraph 85, this says about heading is discussion, finding and reason.
Yes.
So 86 we can escape because that's is a law.
Yes.
87 also we can escape. 88 is a citation of Supreme Court, we can escape. 89 also we can escape, my lord. 89 also we can escape.
The court has started discussion with the law points first.
Yes, my lord. Started with lord. Now we can start from page paragraph 90 onwards, my lord.
At page?
Page 151, my lord. It's just 3 page, my lord.
Yes. Yes.
Now, from evidence adduced,
Yes.
from evidence adduced, there is no denial to the fact that the deceased led Rijit Kurkalang died at civil hospital. Inquest over the dead body was conducted by PW12, the IO, on the said date, and he found some repair wound injury mark on the left side chest and head. Exhibit 8 is the inquest report. The post-mortem report was conducted by, so this all this thing also, my lord, we can escape. 91 also we can escape. 92 also we can escape, my lord. 93 also we can escape, my lord.
Yes.
94 also we can escape, my lord. 95 also we can. Now 96 onwards, my lord. 96 onwards.
Yes.
96.
Yes.
The two most important witnesses of prosecution are PW1, who is a friend of the deceased, and PW9, who is the brother of the deceased. With regard to the identification of the accused person, it is established that the accused Komios Dotodong and accused Lois Dotodong were present on the day of the incident and assaulted the deceased and PW9. From the evidence of PW12, it is found that during the course of his investigation, the test identification period was conducted firstly on 070411, where PW9 identified accused Comios, and in the second TIP conducted on 2608-2011, after accused Louis Dotodong surrendered, PW1 identified accused Louis. During the recording of the evidence before the court, PW1 again identified accused Louis, and PW9 identified both accused Comios and both of them. Coming back to the incident again, the evidence of PW1 and PW9 are important. PW9, who is the brother of the deceased, on the day of the incident, that is on 20/03/2011 at around 2:30 p.m., was found to be collecting fees at Anjali parking lot, and he was the accused person sitting in a local taxi and consuming beer. He asked the accused persons for the parking fees, but they refused to give, and since they refused to give, so PW9 called up his brother, the deceased victim Rijit Kurkalang, who after some time came to the spot. When the deceased came to the spot, they had a quarrel with the accused persons who refused to pay the parking fee. The accused persons, after quarreling, left the place, leaving the local taxi at the spot. PW1 confirmed the deceased victim was with him at Foreign Market, Bara Bazar, when the deceased victim received the call from PW9. Further, it is found that PW9 after some time, the accused persons came back again along with other people who were armed with hammer, iron rod, dagger, and assaulted them. And out of fear, PW9 managed to flee away from the scene, but the accused persons, along with other people, continued to assault the deceased victim. And after assaulting the deceased victim, they fled away from the place. This is also confirmed by PW1, where he stated that when they reached the spot, the incident had already taken place, and 4 or 5 people came to them and started assaulting both the brothers, but they did not do anything to him. PW4 also confirmed that the fight occurred due to a heated quarreling about the parking fees. From the evidence of PW12, it is found that on the day of the incident, he was at the beat house when the 3 persons, namely Kraukupar Wanyang, Comias and Lewis appeared at a beat house at 2:30 p.m. and verbally reported that the vehicle Tata Indica number so-and-so was damaged by some people and all of them were assaulted by some people. Then PW12 made a phone call through mobile number PW2 who was on duty Bara Bazar, informing him that there was an accident in the parking lot just nearby the Cantonment Beat House. PW2 on receiving the said call immediately proceeded parking lot with some CRP person and found one person lying on the ground. On seeing this, he immediately called up PW12 and informed him. PW12 then sent a vehicle, and when the vehicle arrived, PW2 shifted the seriously injured person to civil hospital Shillong. The fact that the disease was alone at the parking lot is confirmed by PW9, where he stated that he managed to fled away and went straight home to inform the relatives, and later on they were informed that the police had come to the spot and taken the deceased victim to civil hospital Shillong for treatment. PW9, after being informed, along with his relatives, rushed to the civil hospital, and on reaching there, he saw his deceased brother was conscious and bandaged. However, 10 to 20 minutes he succumbed to his injuries. This is also confirmed by PW1 that the victim was still alive when he was taken to civil hospital. PW9, after the deceased victim succumbed to his injuries, then filed FIR Exhibit 5, and PW1 confirmed receiving Exhibit 5 from PW9, and after registering the case, endorsed to PW12 for investigation. The statement of PW1 and PW9 was recorded by PW8, the Judicial Magistrate, 161 statement, and as per PW8, she confirmed that she recorded the statement of both PW1 and PW1. Exhibit 5 is a statement of witness PW2, and Exhibit 6 is a statement of witness PW9 as per the evidence of PW8.
Then again, the court has treated Exhibit 6 as a statement.
Statement.
So not a this thing. TIP.
Yes, my lord. So person who had assaulted, coming back to, as per the evidence of PW8, she confirmed that PW9 identified accused Comiers and Kraukuba Wanyang and others as the person who had assaulted the deceased victim and him, and even though PW1 did not know the name of the accused nor describe the physical description, but he saw one of them carrying a hammer. It is also important to look at the evidence of PW7, who was the doctor on the duty on 23/03/2011 and had examined PW9. On local examination of PW9, she found that there was pain and tenderness over the left side of the scalp and also on the left back of the chest. The injury sustained by PW9 as per her examination was fresh. Exhibit 4 is the medical report. The evidence and the finding of PW7 thus confirm and establish the fact that PW9 was assaulted on the day of the incident. Now coming to the evidence of PW12, he stated that on 20/03/2011, 3 persons come to Cantonment Beat House and reported to him that they were assaulted and the vehicle Tata Indica was damaged by some people and they were assaulted by many people. The damaged vehicle was seized and brought to the Beat House, and a separate case was registered with regard to the damaged vehicle. PW6, the motor vehicle inspector had inspected, so this is not very relevant. Thus, the evidence of PW12 and PW6 is a confirm that established that the vehicle was damaged as reported by accused persons to PW12 on the day of the incident. Further, from the evidence of PW12, it is found that he sent Kraukopar, Wanyang, Comiers and Low for medical examination. Later, they returned back to the Beat House for the medical report and shows. So, my lord, all this now exhibit, my lord, what exhibit 112, my lord, what exhibit they have exhibited here. PW, the forensic expert has endorsed. So these are all the medical exhibits. My lord. So
this is all right. There is no dispute with this thing.
Yes, my lord.
The evidence to connect the accused with the
commission
of the crime.
So, my lord, then we'll skip. This is also another 116. Then we'll skip, my lord. We'll come straight to. 117, my lord. 117. PW12 also stated that at the end of the investigation, he filed charge sheet, white charge sheet number so and so against accused Comiers and Lewis under section 304 IPC. Charge was forwarded to PW1. Now, 118. From the evidence as discussed above, it leaves no room to doubt the evidence adduced by PW9 as well as evidence of PW1. The fact that the accused persons, after quarreling with some deceased, victim and PW for refusing to pay the parking
What
fee.
is this? What is para 118 means? From the evidence?
My lord,
Please
from the
try
evidence,
to make the court understand the meaning. Do not read mechanically. Just tell what is this.
my lord, it
Reading it and just tell us.
what I could understand from here is the court is very much confirmed that there is no doubt, there is
But
no
then what this line says from the evidence?
from
it
the
is-
evidence as discussed above, it leaves no room to doubt the evidence adduced by PW1 as well as evidence of PW1.
Okay, so it cannot be doubted.
It cannot be doubted.
Yes.
The fact that the accused persons, after quarreling with the deceased victim and PW9 for refusing to pay the parking fee left the place of occurrence and only to return back with more people and armed with weapons shows the intention of the accused person to cause bodily harm to the deceased victim, PW9. This is further confirmed by PW, where he stated that the accused persons assaulted the brothers and not him. The injuries of the deceased victim, as established by PW5, shows that the deceased victim suffered serious injuries on chest and head, which caused his death. Also, from the evidence, it is found that the offence was committed in the heat of the moment and not premeditated one. But the fact that accused persons left the place of occurrence and only to return back armed with weapons and continued assaulting the deceased victim and PW9 shows the intention of the accused persons to cause bodily harm to the deceased victim and PW9, and they have the knowledge that by causing such bodily harm, they are likely to cause the death of the victim. The court is of the considered opinion that the prosecution is able to establish the case against the accused persons beyond. So this is what. So, my lord, in my humble submissions, my lord, as discussed earlier, my lord, as submitted earlier, my lord. Number one, all these evidences, my lord, totally fail, my lord. Now, the jurisprudence, the criminal jurisprudence says, you must, in order to convict somebody, there must be a reason beyond. There has to be a.
There's a proof beyond reasonable doubt.
Yes. There's proof beyond reasonable doubt, my lord. Where is that evidence, my lord, which would form the opinion of the magistrate to say that yes, these are the proof. So therefore, in my humble submissions, my lord, this conviction cannot sustain in the eye of law, my lord, and I humbly pray, my lord, to acquit the two appellants, my lord. I rest my submissions here, my lord.
Yes, Mr. Gurung, when you will be able to see the records and when you can address the court? Record to satisfy yourself and then
My lord, 2 weeks time, my lord.
2 weeks will be too long. The court will forget
In
it.
between, I have got lots of matter in the DB and all. I have to prepare for that also.
Then again, the court will forget. Mr. Yubin, the points of argument raised by you is reflected in your notes.
Yes, my lord, it is only that point, my lord. I'll cite with some citations, my lord, on that non-exhibiting of the document reliance. I'll just
That is okay.
supplement.
And then you can also see
Yes,
that what are the requirement
yes, my
of a
lord.
valid TIP.
Yes, my lord. I've seen that one, but I've not reflected there. But
In fact, my lord, in the TIP format, my lord, which is enclosed herein, it is exhibited there. What are to be formalities to be observed, my lord.
That's all right. But then non-adherence to do all those things. Anyway, it's all right. It's up to you. 2 weeks is it not very long, Mr. Gurung? But then the problem is that next week.
I
also,
admit, my lord.
No, next week this court also will be. If there are too many matters, then
Exactly,
it becomes
my lord.
difficult.
My lord, hereafter, my lord, in the DB, my lord, I have got 5 hearing matter, my lord. So it happens every week, my lord.
Yes, because
The only
now
thing
the
is-
situation is such
My
that we
lord.
have to
yes, my lord.
cope up with the situation. We have to go
Exactly.
with the situation.
Hence, my lord, I'm praying for 2 weeks' time, my lord.
If it can be accommodated a little earlier or subject to the convenience of my learned senior, because considering the two brothers are they are serving sentence.
You can understand it, Mr. Yuban, but then only thing is that if you fix something and if it is cannot be taken
Yes,
up, also,
yes, that's
that,
also, my
that
lord.
will
Yes.
serve its purpose only.
Yes, my lord.
Just say Mr. P. Yuban, learned counsel appearing for the appellant in both
Yes,
the
my
matters,
lord.
huh?
59 and
60. Learned Counsel for April.
59 and 60.
Has concluded his submission
16 no bullet points.
and submitted a gist of submitted a written gist of and submitted his written gist of argument. Stop. This is prayed for by Mr. Gurung, learned GA. It is this matter after 2 weeks for his reply in the matter. No, for argument by the state, for argument on behalf of the state. We'll have it then after 2 weeks.
My lord, my lord.
We'll try to finish once we start something. It's better to finish it, otherwise things are forgotten. Anyway,
Item 15.
Obliged.
this will have to be kept in the. Just keep it here.
This is a criminal petition for seeking quashing of a proceeding, my lord, on compromise. My lord, there was an FIR filed by the respondent number 4, my lord, against the petitioner herein. My lord, your lordship will find the FIR at page 14. Now, what had happened, my lord, here, there was the respondent number 5 and the petitioner, my lord, they were at a certain place at a certain point of time, and they were drinking rather, and some skirmish happened and they indulged in fight. Now, as a result, both of them sustained injury, my lord, and your lordship, thereafter, the wife of the respondent number 5 filed an FIR. Now, my lord, that led to the initiation of proceeding and a charge sheet was filed. I'll take your lordship to the FIR, my lord, which at page 14.
And you are representing the respondent number 4 and 5?
Yes.
4 and 5, both.
Now, your lordship,
You are objecting to the prayer. Oh no, there's compromise. You're supporting
the compromise, my lord. Now, my lord, the charge sheet came to be filed under section 326. Since it is non-compoundable, my lord, we had to approach this honorable
How many
court.
days the victim was in
No, my lord, he was in fact discharged the very day. I'll take your lordship to the medical report.
Registered on the very day. Can there be a charge under 326?
No, my lord.
Anyway,
That is why, my lord, that plea has also been taken, my lord. That prima facie, my lord, the charge under 326 will not sustain. My lord, this is the FIR at page, my lord, at page 17.
Yes.
FIR against so-and-so. With reference to the subject, I have the honor to state that last night at so-and-so, at around so-and-so, my husband, Shri so-and-so, was assaulted by one unknown person, the name I do not know, at Lapalang village where we are staying, and my husband received serious injury whereby we have to shift him to the civil hospital Shillong and he is being admitted there. Hence, I pray that action may kindly be taken against him. My lord, I'll take your lordship to the medical report of the victim at page 26, my lord. My lord, the nature of injuries are cut injuries, my lord, in the forehead, left cheek, and bridge of nose. And there's a smell of alcohol also detected.
It's okay. This is.
My lord, here the reason.
Of showing these things.
Not exactly, my lord. Now, my lord.
What about the state? What is your thing? Stand.
My lord, we don't have any objection since both the parties have already compromised. My lord.
So, state will not have any objection.
No objection.
Are you both the accused and the complainant? They are resident of the same area
Same area, my lord.
in the Lapalang only.
Lapalang only.
Where is the compromise?
Compromise, your lordship will find at page 39. My lord, at page 41, my lord, the reason has been given as to why they want to, why they have come to a settlement and why they don't want to proceed with the matter any further.
Okay, we will pass order. But then we do not know whether it will possible today.
In similar cases, your lordship has
That is what-
passed many orders, my lord.
This is any order passed last week regarding that compromise. Was it done? It was done by you. Just
Deeply obliged.
16.
send it to my room. This one. Yes,
Please, Lordship. Lordship, very small.
Just a minute.
Yes.
Before you start, sorry. There's an unlisted motion thing which is ready. Unlisted thing is ready. Because, see, we do not know if there is any urgency or because second half this court might have to sit in the division.
Understood.
So, we do not know.
Our matter is not very urgent.
If time permits after DV, then we may take up.
Oh.
Because if there is unlisted thing, then
that is more urgent. I would.
Just let us see and then.
That is more
Would you
urgent.
like to do it today itself?
Next week, man.
Next week we are a bit tight. Things are a bit tight.
Whatever is convenient. 2 weeks.
Lordship, I'm ready. Otherwise, Lordship, we may
No,
have
no,
it
it's
after
okay.
2
If you are
weeks.
ready, then it's okay. Then if you are ready, then court will sit after these things. Then we'll just see. We'll try. If
I
we
would.
can finish.
I would pray, my lord, after 2 weeks.
That is okay. But then if there is any, see, if there is consensus, I mean, there is no problem. But then
Let it come after 2 weeks, Lordship.
since Mr. Pandey is in a hurry to finish.
No, not at all, Lordship. It can come after 2 weeks, Lordship.
Just say on prayer made by the parties, list after 2 weeks.
Lordship, there's a interim order that may be extended.
Interim order passed earlier shall continue.
Obliged.
17.
Before that, anyway, let's call 17. That's okay. Yes.
Very simple prayer, madam. Petitioner is the bailer, my lord.
Simple to you may not be simple to the court. Yes.
Simple. Here, actually, the learned court, my lord, what I am challenging here is the committed some procedural irregularities, my lord. Because, my lord, at the first instance, for non-appearance of the accused, my lord, court can issue warrant of arrest against the accused. Still, if the person cannot be searched out, my lord, then proclamation also can be issued against that person. But that was not done, my lord. Directly, my lord, the learned court below, my lord, issued non-bailable
What
warrant.
stage notice can be issued to the bailer?
Notice can be.
So far as we understand,
My lord.
the non-appearance of the accused,
My lord.
issue of non-bailable warrant, then bailable warrant, non-bailable warrant, and then issue of proclamation.
Well, there is a
Then
provision.
tell us at what stage
My lord.
a notice can be issued to the bailer.
Well, there is a provision in section 489 BNSS, my lord. That provision says, my lord, the bail bond, surety bond can be forfeited, my lord.
Forfeiture is a different thing.
Firstly,
You see, a bailer doesn't just stand, they have to pay money,
my lord.
suffer loss. The bailer duty is that
to produce
He
the
should produce the.
Yes,
He
ma'am.
stands as a surety to produce.
Yes, my lord.
Now, when the trial court finds
My lord.
that in spite of several notices or several intimation, the accused is not
Appearing or
appearing,
my lord.
then at what stage a notice can be issued to the bailiff?
Now at that even after issuance of notice to the bailor, if the bailor also cannot find that person, my lord, maybe, my lord, at the first instance, my lord, he was known
You are not
to,
replying to the query of the court. After the accused failed to appear,
my lord.
then what happens? At what stage bailor can be put under notice by the trial court?
Only at the moment that if his bail bond is to be forfeited, my lord, is required to be forfeited, my lord.
Only in that case.
Only that case, my lord.
So that is these things that you want to say that the bailor has no liability to produce the accused in the court. In his liability is basically confined to the forfeiture of the amount for which stands.
Yes, my lord. That is the liability. That is as per law, my lord. As per CRPC, my lord.
So the accused cannot be possessed. Okay, this is what offence, and when did you stand bailor?
My lord, the offence, my lord, it's an NDPS cases, my lord. There are two accused, my lord, and the present petitioner he took surety of only one of the accused, my lord. And here, the impeachment order, my lord, your lordship will find the only one annexed here. Lordship will find page number 9, the impeachment order.
What is this 528? 520 is 482.
482.
Yes.
Yes, 482. 482. CRPC 482, now it is 528. Here section, my lord, I want to take a lordship to section, my lord, 489, 491, my lord, 491 BNSS, my lord. Here this section says, my lord, procedure where when bond has been forfeited, my lord. Here there is a provision, my lord, subsection to if sufficient cause is not shown and the penalty is not paid.
Wait. Let the court also read. Section
491 BNSS. Subsection 2, because the only liability on the part of the surety that if he also cannot produce the accused before the court in pursuance of the summons or notice, then his surety bond can be forfeited. And for that, my lord, subsection 2 says of section 491.
Have patience. Please allow the court to come to the problem. 491.
491.
Procedure when bond has been forfeited.
Yes, my lord.
Now, where is the question of forfeiture? Before that, what happens?
At the first instance, my lord, the bailor also can apply for discharge before the court. That.
Wait. When a bailor is given notice, asking him to produce the accused, then what happens?
And if the bailor also, my lord, cannot produce him, my lord.
Where is first? Let us start from this.
My lord.
Where is that?
The first, my lord, regarding bond and sureties, my lord, you also will find page section 485 BNSS, my lord. Section 485 BNSS. It speaks about bond of accused and sureties.
Yes, what is your case here?
Here my case is, my lord, the issuance of non-bailable warrant of arrest against the bailor, my lord, that is not provided in the
Just
BNS.
take us chronologically when this, what is the background? The accused is not appearing in this case.
Not appearing in this case, my lord.
Okay, what is the accused? Who is the name? What is the name of the accused?
Raja Bosumati, my lord.
Raja Vasumata.
Raja
He
Bosumati.
stood bailor for Raja Vasumata.
Raja Bosumati.
Now he is not appearing.
Not
So
appearing.
thereafter what happened?
The court below, my lord, issued initially, my lord, BW against me, my lord. So far the impeachment order is concerned, that BW was duly served upon me. Now, my lord, BW only warrant of arrest only can be executed by the police officers, my lord, or the person who is directed to execute the warrant, my lord.
BW was served on you.
Served on me.
In spite of that, you have not appeared before the court.
No, so far this impeachment order is concerned, my lord, because BWA normally warrant, BWA is normally the person to whom the warrant is issued, he is to execute that order.
Go to the
Mal.
thing. Just tell us that after the bailable warrant was executed,
Mal.
you did not appear before the court. Do not question the legality of
Mal.
bailable warrant.
Mal.
Have
Mal.
you challenged it? The issuance of bailable warrant before its execution.
No, Mal.
So it is executed.
Mal.
It is stood executed.
Only after issuance of non-bailable warrant of arrest, I came to know that BW was also issued, my lord.
So BW was never executed.
Never executed, my lord. So, in fact, my lord, the petitioner bailor, my lord, he is willing to appear before the court below, and my lord, since the accused is not appearing, so ultimately the present petitioner is also not able to produce him or locate him, my lord, at this instance, my lord. So ultimately petitioner will appear before the court below, and my lord, if the court below, my lord, direct him to pay the penalty or the should
Whatever according to law, in accordance with law.
In accordance with law, my lord, I am willing to pay, my lord.
See, Mr. Gurung, what is the problem? Fair enough. Let him appear before the court.
That is there, but however, what my friend has submitted that BWA, initially BWA was, my lord.
No, why warrant be issued to the?
Exactly, my lord.
It is not.
Yes.
Procedure doesn't say so.
Doesn't say
He
so.
can be notified. Notice can be issued to him.
Notice can be issued.
And thereafter, if he expresses his failure to make the accused available, then he will forfeit the amount for which.
That is the procedure.
So,
But however, that BWA was not. It was written unexecuted. That is not true, my lord. The very order speaks that BWA issued against the bailor Sri Ravindra Chandra Das returned after duly served. It was duly served.
see, service means it has to be executed. It cannot question of service.
Exactly.
It has to be executed, and the undertaking has to be taken from him that he will appear before the court.
What is submitting is not.
It is not mere service of notice.
My lord.
Warrant execution of warrant.
Yes.
Now, whatever the thing is, there remains a question whether court was correct or not in issuing
No, my
BWA or not.
Absolutely not.
If he undertakes to appear before the court on certain day, we'll record that.
Yes.
And we'll just say that NBW, that's the order will remain.
Yes,
That is
Yes.
seems to be this thing.
That
What
is
the
the
order? What is the order, Mr.?
Page 9,
Page
9,
nine,
page number 9, my lord. Order dated 11/4/25, my lord.
Yes.
Well, next this is on 30th of June, my lord. On that day, my lord, I will appear, my lord, before the court below, and
Only thing is that court might be wrong in issuing some warrant, but then once it is executed,
my lord.
it is your duty to appear.
Exactly.
Do not appear. Order may be right and wrong, but it has to be implemented so long the order stands.
Lordship, that is
That
correct.
has to be. That has to be.
My lord, I'll complain hereafter.
Return after duly served. What is this? Anyway, this present application has been filed by the petitioner against impugned order dated 11/4/2025. Passed in session case number 30 of 2016. Order dated, yes, passed in by order dated 11/4/2025.
Yes, ma'am.
In
Yes,
session case number
ma'am,
30 of
ma'am.
2016 by the learned session judge, River District, whereby a non-bailable warrant of arrest, NBW, just say, was issued against the petitioner. Give a paragraph. Stands. The effect of the case is that the petitioner stood as a surety.
One of the accused, my lord, Raja Boshu.
Just a minute. For accused Sri Raja Basumatari. Who is a co-accused in NDPS case number
Nothing like that.
31 of 16, my lord.
31 stroke 2016. Pending
It's
before
32, no?
31.
Okay, 31.
Session case. This is
this 31, is it?
31 minutes.
31, my lord. Session case number 31.
Pending before the session judge. Nangpo. Stop. It appears that because of non-appearance of the aforementioned accused person before the trial court, trial court, comma, a non-bailable warrant was issued against the petitioner by the impugned order dated 11/4/2025. Stop. The contents of the order revealed that the issuance of NBWA was necessitated by non-appearance of the petitioner in pursuance of previous issuance of a bailable warrant in the matter. Stop. Give a paragraph. The learned counsel for the petitioner contends the contents that the learned trial court was not correct in law in issuing BWA as well as non-WA against the petitioner, as no such procedure is prescribed in the criminal law. However, it is fairly submitted by the learned counsel for the petitioner. The petitioner is willing to appear before the trial court on the
30th June, my lord.
next day. Then we give IE 36/2025. To what is it? However, however. So 36 instances and prayed for. Stay of the order dated 11/4/2025 by which non-bailable pray for stay of the execution of the non-bailable warrant of arrest issued against him. Give a paragraph. The learned J. appear for the state has no objection to the prayer made by the petitioner. However, he submits that in case of default of appearance by the petitioner on the next date fix, the NBW issued against him may be allowed to execute. Your paragraph. Just say in view of the submission made by the learned counsel appearing for the parties, this petition is disposed of by directing. But then to whom we should direct? Not to execute the
My lord, the imperial order may be suspended. Suspended or set aside with the direction to the petitioner to appear before the court below. My lord. That will serve the purpose. My lord.
just we say in what we said in view of the submission made by the parties. That is the order dated 11/4/2025. It is set aside insofar as it concerns the issue of non-bailable warrant against the petitioner. The petitioner is directed to appear before the trial court, appear before the appear before the court of session judge.
Yes, madam.
Nangpo on 30/6/2025 without fail. Stop. It is made clear that in the event petitioner fails to appear before the court for the next date, the under trial court may proceed to get the NBW executed. Stop with the above. This petition stands disposed of. Yes. Make sure you appear.
Yes, madam.
If you have any grievance with regard to the procedure adopted, then come and challenge it before it is executed.
My lord, I will appear, my lord. Even
Your conduct in, you see, like accepting or coming to know about the BW and thereafter not appearing is something.
I'm admitting, my lord, at this stage. Otherwise, my lord, I will appear and I will even make proper objection before.
Litigant should be fair, you see. That is the
My lord, I'll do it.
Yes.
I'll
Definitely.
Second call, list item 17.
Yes. Dr. Mojika.
Lordship, here, Your Lordship, the main party is the CBI, Your Lordship.
Dr. Mojika represents and then.
Lordship, last time he entered appearance, Your Lordship, and sought for time.
Yes, that is what the order says.
Lordship, yes. Because the state will have no role, Your Lordship, since the matter is being investigated by CBI and charge is also submitted by the CBI.
So it will be difficult without him. Yes, Mr. MS ADC Learned Counsel is present on behalf of the petitioner.
We are for responding.
Also, Mr. Andy Shulai, Learned AG.
For R1, Your Lordship.
Mr. Andy Shulai, Learned AG, along with Ms. R. Conley, are present on behalf of respondent number 1. Dr. N. Mojika, Learned DSCI, appearing with the respondent number 2, is absent.
Your Lordship, I have also made an interim prayer, Your Lordship, to stay.
But then, if the main contesting party is not absent, then it becomes difficult. Just list it matter after. Number 2, Mr. So and so. What is it, Mr.? Just no, just there's the after record your appearance photo. Shall I? Just you say there is no appearance for the respondent number 2, who is stated to be the main contesting respondent.
Contesting party.
In view of the above, stop work for hands of justice. List is matter after 2 weeks.
Apply, Your Lordship.
No other matter. In type of that we use this one, which I have dictated the unlisted matter. After that,